Welcome to our session, which is entitled Piercing the Corporate Veil, How Jurisdictions Differ. We started this panel session in London a few months ago, and when you think about it at a very basic level, what are we talking about when we're talking about offshore jurisdictions? We're talking about entities that are incorporated in offshore jurisdictions that, I'll wait, that are being utilized to fund and really accomplish the fundamental business of the world economy. What we're going to be talking about today is the circumstances by which one company can be held liable for another's debts, shareholders can be held liable for a company's debts, and the circumstances under which the general rule of corporate limited liability will be broken when the circumstances permit. Why are we going to do that? Well, sometimes there's fraud and sometimes there's bad actors. Sometimes corporations, which obviously have their purpose, are used for a purpose which is not in keeping with the reason corporations exist and are protected in the first place. So what are we going to talk about today? We're going to provide an overview and comparative perspective as to the law of veil piercing in three fairly significant jurisdictions for this crowd. Those are the United States, offshore jurisdictions, including Cayman Islands and the British Virgin Islands, as well as for the first time this session, a Western European and arbitral perspective on similarly the circumstances where the corporate veil will be pierced. I'd like to introduce my esteemed co-panelists. Mark Goodman, partner at Campbells, which is a Cayman and law firm with offices in a number of jurisdictions, as well as Ivan URZHUMOV. He is an attorney with Foley, Hoag in Paris, and we've been working together on a number of cases as of late involving asset recovery and piercing the corporate veil, so I do know that he knows his stuff. And without further ado then, I'd like to turn it over to our first segment here, which is the Cayman Islands, and of course we all know what Cayman lawyers actually do. And with that, Mark, can you take us off and give us a bit of the overview of piercing the corporate veil in the islands?
So we did this talk in London in November, and you'll probably notice that since that photo I've put on a bit of holiday weight, so don't judge me. Now, the starting point for, I'm going to have to talk about English law because Cayman and BVI law is essentially the same as English law. I said last time I spoke on this that Cayman law is English law for dummies, but somebody was upset about that. So I'll say BVI law is English law for dummies. The starting point is a 19th century case called Solomon and Solomon, which the court said the corporate personality had to be respected, that the intention of the legislature must have been to recognize the separate personality of a company, otherwise they wouldn't have allowed incorporation. And as a result of that, we have what we now call the unyielding rock of corporate law in the Salomon principle, which is that corporate personality will be respected. There are some exceptions to that. There is a development of case law in the UK which has been applied in both Cayman and the BVI and most other comparable jurisdictions I'm aware of, which you can pierce the corporate veil in cases involving a facade or a sham. So what we mean by that is a situation where the company is used to either facilitate a fraud or where the company is used to allow somebody to evade an obligation which they owe. So two early examples of this kind of case. Trustor and Smallbone was a case involving a trustee who incorporated an offshore company to divert the proceeds of a fraud. He defrauded the trust and sent the money to an offshore company. And when he was sued, said, well, the money's not mine, it's a company. And the court said that the company there was a sham. It was a facade because it was used purely to allow him to avoid an obligation he would have owed were it not for the company. Another example, not all of these piercing cases involve that kind of outright fraud, but another example Guildford, Motorco and Horn. That was a case where the owner of a business sold his business, gave a non-compete undertakings to the purchaser of the business, and then set up a company which provided exactly the same service that he'd undertaken not to provide. So that was an example of a company which was used as a facade to allow him to avoid contractual obligations he owed to the contracting counterparty. So what we have in the UK, in Cayman and in BVI is a general reluctance to allow the piercing of the corporate veil, but the court will pierce the corporate veil in appropriate circumstances. The court will refuse to pierce the corporate veil unless those exceptional circumstances exist. A case in Cayman, Walker and Olieris, where the court found that although these offshore companies were set up to facilitate the avoidance of tax, these were not a sham. It was a perfectly legitimate corporate structure, perfectly legitimate transaction, and there was no evasion. There have been attempts in Cayman to widen that jurisdiction. There is a case called Bonotto and Boccoletti where the Cayman judge found that there was impropriety and that it was in the interest of justice to allow the corporate veil to be pierced. But that's an anomalous decision. It's not been applied, it's not been followed. Similarly, in another Cayman case, an injunction case, which concerned whether or not certain non-cause of action defendants could be considered to be amenable to an injunction on the basis that the assets of those companies would eventually be available to meet the judgment against the controlling mind of the companies. And what Justice Henderson said was that the fact that those assets would probably ultimately be available to meet the judgment was a reason to allow an injunction against non-cause of action defendants. The Court of Appeal overturned that and said that was, of course, wrong, that these very limited exceptions should be preserved. So, the modern test is found in a 2013 case, an English case called Prest and Petrodel. Situation was Mr. Prest is divorcing Mrs. Prest. He transfers the matrimonial home and various other properties into a company. I think in that case it was a Gibraltar company. Petrodel Resources. Mrs. Prest sued and said that these properties they were matrimonial assets, they belonged to him. And what the court said was, this is Lord Sumption, the conclusion was that there was a very limited principle of English law, which, as I said, has been applied in Cayman and the BVI, which means that you can pierce the corporate veil where there has been evasion. So it wasn't an issue of control, it wasn't a question of impropriety, it was a question of whether somebody had evaded an obligation that they owed to someone else. What Lord Sumption said in that case, and this is the real interesting stuff that we are going to talk about, is what you do as an alternative to piercing the corporate veil. So what Lord Sumption said was that piercing the corporate veil was a remedy of last resort. You only pierce the corporate veil when there's no other solution. And here is two solutions which were referred to in that judgment as being solutions to the problem, and then two other suggestions of ways to solve the same problem. So in Prest and Petrodel, the court found that there was a resulting trust. Mr. Prest had transferred these assets to the company. The company had not provided any consideration for the gift of the assets. There was no evidence to rebut the presumption against a gift. And in the circumstances, the court found that these assets must be held on trust for Mr. Prest. So although they didn't pierce the corporate veil, they found a solution. Again, a common thing you'll see with offshore companies is they are asset holding companies. They hold one or more assets. It might be shares in a subsidiary, it might be properties, but they will hold an asset. And often those assets will have been transferred to the company as part of a structuring arrangement which involves the provision of no consideration. So we would commonly expect to be able to bring recovery action against a company defendant on the basis that the assets transferred to the company gave rise to a trust. The second kind of situation, the Trustor and Smallbone case, and Genco and Dolby is a very similar factual case where assets were transferred to a company to avoid the risk of recovery by the person who was defrauded. And what Lord Sumption said in Preston Petrodale was, this is an example of agency, where the company receives those fraudulent proceeds from a trustee or a director of a company who diverts business opportunities to a company for his own benefit. That's an example of agency. The company receives those assets as an agent for the principal, who is the person who's diverted the interest to the company. Direct causes of action. It's beyond the scope of this talk to go into all the detail of the different causes of action which would be available to somebody who wanted to sue a company, but the obvious ones are things like knowing assistance, money hadn't received, knowingly assisting a breach of fiduciary duty, conspiracy. Those are examples of claims which you wouldn't need to pierce the corporate veil, because you would be suing the company as a party involved in the fraudulent transaction. Chandler and Cape is an interesting case. That was a case involving a structure of companies where, to do with mesothelioma cases, the asbestos cases, the defendant who owed the liability had been dissolved and no longer existed, but its parent company provided medical assistance to the victims. It set up a fund to assist them with their care, and the court found that they had assumed that responsibility, even though the company which owed the duty had been dissolved. The company which had taken on the responsibility of providing this assistance was deemed to have assumed the liabilities of the subsidiary. So again, another example of a situation where you don't need to pierce the corporate veil. You can find someone else who is responsible. You can sue the company as part of the claim. The last one is liquidation. Quite an appropriate analogy for an offshore alert conference. Somebody said to me once that fraud and insolvency go together like alcohol and hangovers. You don't always have a hangover when you drink, but there's a good chance you're going to. And actually, my preferred solution in this situation, and what we see most commonly, is a liquidation. Why? Because the liquidator has various powers which go beyond that which a normal litigant would have. You have the ability to investigate the affairs of the company. You have the ability to require production of documents, to procure assistance from service providers, directors, officers, auditors, various other people, which allow you to uncover and assist in making recoveries in the fraud. So we're working on a case at the moment where $650 million was raised by way of an IPO. The money went through a Cayman company into Hong Kong and then disappeared somewhere into China. The wife of the principal of that company, the day after the IPO closed, bought 8 properties in Hong Kong. That year declared $100 million of gambling loss on a tax return. So what do we need to do there? It's not enough to pierce the corporate veil and look at the principal and say, where's the money gone? We need to understand where the money's gone. We need to trace the assets. We need to understand. So in that case, we subpoenaed 20 casinos in Vegas to try and understand where the money had gone. How can we get it back? That's the powers you have as a liquidator, which you would never have as an ordinary litigant. So actually, Lord Sumption said, resulting trust and agency. Warren's going to talk more about the US approach, which is they're far more willing to allow the corporate veil to be pierced. All I needed to say at the start of this talk was, don't even try and pierce the corporate veil, just put it into liquidation. You're either a creditor or a shareholder, you have locus standi to petition, you get the company into liquidation, independent fiduciaries have all of their investigative powers. That is your fastest and most effective way of making a recovery. So here's some examples. These just to highlight the fact that when you look at these are the English examples, and Bolotto and Boccaletti at the bottom of Cayman case. These are English examples of piercing the corporate veil. They are not always offshore companies, but very often they are. I could say that offshore companies and veil piercing is like alcohol and hangovers, but I've already used that joke. So what we see in the English court is fairly frequently offshore companies being pierced. That's it for me. This is Warren's going to talk about the US.
Thanks, Mark. The US side is markedly different. The answer in the US is we still have a very strict rule concerning corporate limited liability. The world wouldn't function without it. That being said, it is absolutely possible to pierce the corporate veil in the United States. Now, to deliver a talk about U.S. veil piercing in 20 minutes is a little difficult. We do panels like this just talking about the differences between the standards for veil piercing between and amongst the 50 states. You can go an hour on each one of those differences. There's also a federal veil piercing standard. What I'm going to try to do here is provide a very broad overview, because the themes, no matter how you deal with it, are all the same. You're talking about fraud. You're talking about a group of people against whom a corporation has been used to achieve an inequitable result. That's all that's saying up there. When you are talking about management engaging in domineering behavior, sometimes it's a subsidiary dominating a parent. Sometimes it's the intentional dissipation of assets between the corporate structure, the owners, and affiliates and subsidiaries. The answer in the U.S. is that while easy to allege and difficult to prove, piercing the corporate veil is possible. We did it just last year at trial. I should say it was an interesting case because the lead witness for the companies whose veil was to be pierced, he left the stand in the middle of the cross-examination. After day one, he realized things weren't going so well. The result was a trial verdict. We have done it in a number of other cases too. So the answer is you do give it a shot. You give it a shot whenever you have a piece of evidence which leads to a truly inequitable result. Some use of a company that simply falls outside the intended purposes of companies. We also have a very interesting jurisdictional proposition in the United States. And it's something that, to my knowledge, doesn't exist anywhere else. When you are piercing the corporate veil and you have jurisdiction over one alter ego, i.e. one affiliate, one shareholder, the person against whom you're bringing your direct action, you have jurisdiction over them all. It's interesting. You have to win in order for the jurisdictional question to be answered, but you can bring your complaint in the United States against 20 companies, only one of whom is subject to nominal personal jurisdiction in the U.S. So what this means is it is possible to engage in a plenary veil-piercing exercise via the U.S. courts. Most famous example of this recently was probably what Judge Rakoff did in the Uzan case. The Uzans were a very prominent family, political family in Turkey, and they got into a situation where they owed Motorola and Nokia in excess of $1 billion. And they used in excess of 137 offshore predominantly, but also Middle East shell companies to obfuscate and hide their assets for years. The result, after a surprisingly short period of time, because when you refuse to defend yourself, it's hard to put up a defense, was that Judge Rakoff pierced the corporate veil of all 137 companies. All of them. Anyone who was found to be a facilitator and a contributor, the entire debt was transferred onto them. So you compare that to systems like fraudulent transfer, what some call undervalued transfers, preferential transfers, where at best what you're talking about is getting the money back with interest. What we're talking about here is liability shifting. So it can be a very powerful weapon, and this jurisdictional hook is something that makes the litigation very attractive. Now, a question that's bubbling its way through the courts right now is the usual rule is you look to the jurisdiction where a given company is incorporated and apply its law when trying to pierce the corporate veil. Its law, colored by U.S. judges and juries, it always makes interesting anyway. When you're dealing with 30 companies, maybe 20 of whom are incorporated in different jurisdictions, applying 20 different sets of veil-piercing laws to the same case and maybe a jury trial where you are having to explain this to a jury of peers, non-lawyers, can be very difficult. What I can tell you is that in a complicated case like this, there's no binding precedent yet, but what there's a tendency to do is to apply the U.S. state of incorporation standard. And so it's forming its way through the system. In fact, when you present this to a victim, an aggrieved creditor, and of course they say, well, what laws can apply? You say, well, it's not quite clear yet. What is clear, though, is that there is an increased willingness to pierce the corporate veil, and I think it's a product of 2008 and onwards. When you have a major financial crisis, and I think the joke was used there, you see who's swimming naked when the tide comes out. And what that produced was a lot of course, major fraud cases, like your Madoffs and your Stanfords, but a whole group of cases where the corporate form was being abused. You have assets being commingled. You have entities and subsidiaries being dominated. And so a whole group of the cases that you're seeing winding its way through the U.S. court system, and there are a lot, actually arise post-2008. And again, I'm trying to give a brief overview. If you type veil piercing into Westlaw these days, I think I did it a couple of days ago, there was more than 2,500 hits, and that's just the reported cases. So these types of cases are going on in the U.S. at a very substantial level. Another corollary to these veil-piercing actions is that there's usually a purpose. Somebody has been defrauded. You are generally trying to stop whatever is going on in its tracks. I mean, I've got a case right now which appears to be a serious energy fraud where you have letterheads with typos, bills of lading number 1 and 2 for companies that were supposed to be in business for years, vessels that don't exist, serious indicia of fraud. And so what are you supposed to do when there isn't time to go through 3 years of litigation to get to a judgment? Where pre-judgment attachment goes in, and tomorrow we are going to get in the advanced investigative and asset recovery session. We're going to get into this a lot, but it's a particularly important component of a veil-piercing exercise because often there isn't time to wait. If you are talking about actors who are engaged in either lowercase fraud, fraudulent transfer type activity, or capital F fraud with forged documents and the like, you may not have 3 years. And the way to obtain one of these attachments is simply to show a probability of success in the merits. It's tough. You haven't got your discovery yet, so you need a hard piece of evidence right at the outset. But we've gotten these types of orders in a whole variety of cases. And again, when you combine it with the jurisdictional point, you're talking about situations where, let's say you've got a $50, $60 million claim, you can get an attachment order against 20 or 30 entities for the full amount as to each. There are consequences, bond and damages if unsuccessful. You pay attention. It is a serious exercise, but when you use it, it's usually because the circumstances are serious. Mark talked a little bit about what is effectively the wink and the nod guidance from the UK and the Cayman law system saying don't really try to pierce the corporate veil, get around it. The irony is it's actually the reverse in the United States, but we do have some similar principles. We have equitable receiverships. We also have recognition of and this is a double workaround. If Mark can get you the type of receivership, winding up petition, or equitable trust in a foreign law country, we can often have that recognized in the United States. So when we're talking about getting around the veil, that's what we're talking about.
And actually, we've had cases where the victims of the fraud haven't had standing in Cayman to do anything. So they go to New York, get a judgment. They come down to Cayman, wind the company up. They go back up to New York and get Chapter 15 recognition. So it can be very circular. But the point is, I think in both jurisdictions, you have to get to the top of the snake and you have to cut the head off. And the way to do that is by working across jurisdictions. These kind of cases, as you can see, the number of offshore cases that veil is pierced in is because these are the most common vehicles for fraud. And so what you will find generally is structures which touch on 4 or 5 different jurisdictions to try and make it as difficult as possible to unravel the whole thing. Well, actually, if you combine this with injunctive relief and you work closely with your colleagues in the other jurisdictions, you can actually get a very effective, a very efficient recovery.
Oh, I agree. I mean, this is the point, is you want some version of a team that's sitting up here right at the outset, because this is all multi-jurisdictional. You want to use the tools that are available in each jurisdiction to accomplish your goal. And of course, in these cases, most of the cases that I work on are, frankly, victims' work, plaintiffs' work, but obviously there's a defense side as well. You want to, it's the right tool for the right job, and we actually commented on tomorrow as well, it's jurisdictional arbitrage. It's finding how and by which tool in any given jurisdiction you are going to achieve success. And usually we are defining success as the best recovery for your client with the least overall costs and risks. My last 5 minutes I'm going to take to highlight to a group here and a couple of issues that have sort of crossed our desks recently and pose 2 questions, which is something we always like to do to get people thinking. The first concerns what is being pitched by entities around the world, restructuring advising entities and lawyers, as what I'm going to call aggressive out-of-court restructuring proposals. And this is particularly going on in the wake of what is a very serious energy crisis. I'm sure a lot of people in the room are dealing right now with the fallout of falling energy prices and these bankruptcies. And the proposition here that we're going to examine for 2 minutes is, what about the restructuring plans that I'm going to say fall on the more aggressive side of the spectrum? The restructuring plans that are effectively changing the debtor in respect of mezzanine debt, unsecured note holders, notes held by hedge funds that are, let's say, notorious for getting every dollar back. I think that in some cases, if you look to the economics of the underlying plan and you have them neutrally evaluated, and the answer to whether this restructuring adds value is that it's either nominal or doesn't really, and the practical effect of that restructuring is to further put assets beyond the reach of creditors. If those 2 conditions are met, my suspicion is that creditors will take to piercing the corporate veil, principally via the United States, and because so many bonds are New York law governed, it'll probably be in New York. Just think about it. Why is the restructuring happening? Is it purely to buy time? Is it benefiting management? Is it for the express purpose of putting assets beyond reach? Well, before you litigate the case, you won't know, but what it's going to come down to is intent. What you're going to be standing in front of is a jury, and you're going to see all of the emails that were sent associated with this restructuring. Some privileges will apply, some won't. And in the case where you can prove wrongful intent, I think there's going to be a very good argument if you go back to the original definition of restructuring at the first slide, which is wrongful use of the corporate form, inequitable conduct, inequitable results. That's the test for veil piercing, basically, in the U.S. So it's an interesting thing that's going on now, and I think you're already seeing in Europe some pushback to these out-of-court restructurings. If they're using a different mechanism, they're effectively blocking them using injunctive tactics. But this is simply the other side of the coin, and it's a little easier to accomplish. The second question that I'll pose is a pretty basic one, and I think it's appropriate for a conference like this, and that is, are all corporate veils cut from the same cloth? Are they all, should they all, be equally hard to penetrate? It's a normative question. It's a question that is one of policy. Now, I can tell you on the U.S. side, the answer is no. It's been no for 40 years in two contexts. First of all, the most basic distinction is that you learn in law school, it's easier to pierce the corporate veil if your claimant is a tort victim as opposed to a contract victim. Contract parties, you can negotiate guarantees. If you didn't negotiate a guarantee, maybe it's your fault. If you're a tort victim and you didn't even maybe intend to do anything with this party, well, then it's always easier. Another big example of it being easier to pierce the corporate veil, and there's a whole line of court doctrine on this for 40 years now, is in the case of shipping. In shipping cases, in cases that fall within the U.S. court's maritime jurisdiction, it is simply easier to pierce the corporate veil. The reasons for this going back 30 years are on the screen. Due to the unique corporate arrangements that exist in the maritime industry, federal maritime law has adopted unique rules governing corporate liability. It applies irrespective of whether a company expected ex ante that their corporate relationships would be scrutinized within a maritime action. This is the law all over the United States. It's federal law. So the question, and this is the normative one, and this is where I'll leave it, if you just took out maritime from that sentence and inserted offshore, and you examine the unique arrangements that exist in the offshore world, does this logic apply? And this is how I'm going to tie it into Mark's point. A lot of the U.S. cases where the corporate veils have actually been pierced, whether via effective settlement or at trial, involve offshore companies. In half the cases Mark put on the screen in England, the corporate veils were pierced, it was offshore companies. So it's not just that I'm asking this question of should this be the rule in the case of offshore companies. Is it already the rule? Are we already there and we just haven't realized it? And so those are the thinkers that I'll leave you with, and after Ivan's session, we'll also have a question session to open to the floor thoughts and panels, thoughts and questions. And with that, I'll turn it over to Ivan, who's going to give us the European perspective.
Just before Ivan, before I give the microphone to Ivan, because I already had it, so I'm going to hold on to it. The policy in the UK, Cayman BVI, as we saw from the Preston Petrodale case, is actually the opposite of that.
We have completed our testing of the alarm system. Thank you for your understanding towards life safety. Thank you again and have a nice day.
Even with a microphone. So the public policy in the UK, Cayman and BVI, has gone in the opposite direction. The principle... I'm going to give the microphone to Ivan.
Thank you for the gift.
I think we had hardship points for this one.
Thank you, Warren and Mark, for your presentations. And so let me speak a little bit about the French experience and also the experience of other European countries which have a civil law background. And I will also touch upon the same question of pierce of corporate veil in the context of arbitration proceedings. So, by way of introduction, first, why is it relevant at all to consider this question for French and other civil law jurisdictions? I think there are two practical reasons. First, very often the assets that you are going to recover at the end of the implementation of the recovery strategy. So it is the assets of the ultimate beneficial owners of the companies which defrauded the creditor. Very often these assets are located in France or in other European countries. So you need to know in advance what will be the practical effect of the pierce of corporate veil judgment in France, and whether you can either enforce a foreign judgment piercing the corporate veil, or maybe directly obtain a French judgment which will pierce the corporate veil. The second practical point is that France is one of the busiest arbitration places in the world. And I think that one potential route for piercing the corporate veil is by using the arbitration. And I will speak a little bit about that point later in my presentation. So, is it possible at all to pierce the corporate veil in France? Strictly speaking, there is no such theory as in the common law jurisdictions, but there are alternative legal mechanisms which sometimes may allow you to reach the same results. And in fact, very much very much depends on the particular circumstances of the fraudulent scheme. And I will always recommend you need first to know the facts to have then to find then a legal mechanism which will be the most appropriate depending on these facts. And one of the theories that allows you to sometimes obtain the liability of the parent company is the so-called interference theory. It is based on the more broad theory which exists in French law, the theory of appearance, théorie de l'apparence. And French courts use it in a very broad number of circumstances. But for the purpose of piercing the corporate veil, one of the latest published decisions of the French Supreme Court has identified two requirements which are necessary to obtain the liability of the parent company. First, there must have been a significant interference of the parent company in the activities of the subsidiary. It may be, for example, that the mother company took decisions which normally must have been taken by the subsidiary, or it negotiated the contract in place of the subsidiary, or also participated in performance or termination of that contract. And the second requirement is that as a result of this interference, the creditor of the subsidiary should have legitimate expectations or a legitimate belief that the parent company replaced the subsidiary in the legal relationship with the creditor. So this theory is more based on the legitimate expectations of the creditor. It is not about the fraudulent transfer of assets. But in the situations where the assets of the creditor, of the debtor, have been fraudulently transferred to a third party, there is another more, also a very general theory which exists since the Roman times, and it is called the Polian action. So the Polian action basically allows a creditor of a debtor to bring a claim against the third party to which some assets of the debtor have been transferred fraudulently. And if the action is successful, you will be able to seize these assets which were transferred fraudulently to enforce your claim. So the basic requirements are three. First, there must have been an act accomplished by the debtor by which the debtor transferred some assets to a third company, which may be either a parent company, for example, or another company of the same group. The second requirement is that as a result of this act, the chances of recovering the claim, the debt against the direct debtor have diminished. And the third requirement is the requirement of fraud. There must be showing that the debtor and the third party were colluded to defraud the creditor. And one example of which we can think in the context of offshore company is a case on which I worked recently. It involved a Russian company which was defrauded by the management of this company. And the company made a loan first to a Cyprus entity, which then loaned the same amount to a French entity, and the Cyprus entity assigned the rights under the loan agreement to another company. And in this situation, it is possible to challenge this chain of transactions under the Pauline action theory, and eventually to assert that the French entity which received the loan shall be held liable to the creditor of the Russian entity. So also French law provides some additional tools which apply in case if your debtor is a French company which is facing bankruptcy proceedings in France. So this is a legal, there is a legal provision in the French Commercial Code which states that the liquidator can bring an action against a third party to extend the liquidation proceedings to the assets of that third party. And it is possible in two situations. If the debtor, the main debtor who is facing the bankruptcy proceedings, is a fictitious legal entity, but honestly, this is never the case, and it is really very rare that French courts recognize that they have been that the company was fictitious. Or the second ground, which is more common and which the courts sometimes more readily apply, is that the insolvent company's assets were intermingled with the assets of the third party. So it can be the assets of the parent company or another company of the same group, or if there were some abnormal financial flows between the two companies. But this action can be pursued only by the liquidator and not the creditors independently of the liquidator. So the conclusion for France is that first, there is no pierce of veil theory. There are legal instruments which sometimes can be helpful, but everything depends on the facts, and it is, I would say that the pierce of corporate veil is perhaps more difficult and less generalized than in common law jurisdictions. Now, just quickly, we'll have a look at the other European jurisdictions, just to have to give you an idea of what can be the approach of other countries. First of all, I would say that it is a mistake saying that all civil law countries apply the same approach and that all of them are hostile to the pierce of corporate veil. Actually, you have to determine in each situation to see to the legislation of each different state. And I have an example, a good example of of Spanish law, which does recognize more broadly the possibility of veil piercing, and it even uses this the case law of the Spanish Supreme Court even uses the terminology of levantamiento del velo, piercing the corporate veil. And from my experience, the theory is applied. This theory in Spain is applied more easily than its alternatives in France. Now, as I was saying in the beginning, an important reason why you have to consider France and other European jurisdictions is arbitration. Why is that? Because, as you know, many of the international contracts nowadays, if not most of them actually, contain arbitration clauses which provide that all disputes arising out of the agreement have to be submitted to the arbitration. And very often the arbitration is seated, the seat of the arbitration is in Europe, including in France or Switzerland, Sweden or Sweden or another country. And by the way, France, I think, is one of the leading arbitration places in the world in terms of number of cases that are seated there. So consider the situation when you have a contract with an offshore company, and that contract provides for arbitration seated with a seat in Paris. And of course, the offshore is an empty company, and you are asking yourself if it is worth at all pursuing an arbitration against an empty company to then have an award which will be just a piece of paper and will not allow you to actually enforce. And the good news is that, in fact, there are possibilities, and it may be possible to reach other companies of the same group and to pierce the corporate veil in the arbitration. But in order to achieve that result, actually the veil will have to be pierced twice. First, for the jurisdictional purposes, and second, for the merits. I will explain it now. So the jurisdiction, the general rule in arbitration is that the jurisdiction of the arbitral tribunal, so the power of the arbitrators to rule on the case, is based on the consent of the parties. So there must be an agreement of the parties to submit the case to arbitration in order for the arbitrators to have jurisdiction. If you have a contract with an offshore company A, obviously, or prima facie, the parent company B will not be bound by that arbitration agreement. But the good news is that under French arbitration law and the practice of the French courts, there is a very favorable theory which allows to extend the arbitration agreement to non-signatories. So any company which belongs to the same group as the signatory, which participated in the negotiations, performance, or termination of the contract, or otherwise was involved in the project or contractual relationship, may potentially be attracted to arbitration and be bound by the arbitral award. So this is possible under French law if the arbitration is seated in France. I know that similar theories exist in Switzerland and other European countries, but maybe they are less favorable to the extension of the arbitration agreement to non-signatories. So once the arbitrator has decided to extend the arbitration agreement and to assert jurisdiction upon a non-signatory, it will still have to determine the substantive liability of that non-signatory, which in our case is, for example, the parent company of the signatory. And in determining the existence of a substantive liability, the arbitrator may follow two alternative routes. Either it will apply the national law of a country, but in this case it will have first to determine which is the applicable national law, and it can be a quite difficult task in the context of international disputes. Or the alternative route would be to apply what is called the lex mercatoria. So this concept refers to a body of unwritten, actually, principles of international commerce or trade usages. And what is good is that there are several arbitral decisions, and also there are positions in the arbitral community expressed to the effect that the pierce of corporate veil theory is part of the lex mercatoria. So if the arbitrator applies the lex mercatoria, there are chances that it will pierce the corporate veil. And what is even more interesting is that even if the arbitrator applies a national law of a given country, for example, in our case, a French law, it will not necessarily apply that law in the same way as the French court would have applied it, because an arbitrator has, in any event, to take into account the international context of the dispute and the existence of international trade usages. And so the arbitrator applying a French law may more easily come to the conclusion that the veil has to be pierced and that the corporate layer has to be disregarded.
By the way, I'll take this back to the general form. Just imagine how hard doing this is in a second language, so that was fairly impressive. But this arbitral point is very important when it comes to an international recovery fraud exercise. I'm dealing with a case right now, arbitration award issued out of Paris against a company, and the award itself pierced the corporate veil to the ultimate beneficial owner of that company. A lot of times, and frankly, the conventional wisdom has been to get your award against your counterparty and pierce the corporate veil in a given jurisdiction where there's assets. I would question whether there is genuine merit to going the other way. And from what I'm seeing, the answer seems to be yes. It's not just that France in particular, but frankly also the United States has somewhat more liberal rules in terms of bringing non-signatories into an arbitration. It's not really veil piercing, but it really is bringing them into the action, and then you decide veil piercing. Once the award is rendered, there's virtually nothing you can do to stop the enforcement. Judgments of various courts are often harder to enforce in other countries than awards. When it comes to awards, we have the New York Convention. And I say even, but even China is party to the New York Convention. You can, it's difficult, but enforce arbitral awards in China. You can't enforce a US judgment in China. You can't enforce a Cayman judgment in China. The other issue is that overturning an award is extraordinarily difficult. It is much more difficult than appealing a judgment. Just ask Tom Brady. He thought he had it, but then they brought it back on him and upheld the award. Absent a complete disregard for the law, the award will be upheld. And so this phenomenon, veil piercing within arbitral awards and using that as the springboard, I think it's very important. It's one of the really good.
Yes, I agree. And actually, it is generally one of the reasons why we choose arbitration is that the arbitral award can be more easily enforced worldwide. And also for the fact that to set aside an arbitral award is quite difficult but it depends again on the seat of the arbitration. And for example, in France and Switzerland, it is really difficult to set aside an award. In some other countries, it may be more easy. And one recent example is the URZHUMOV award, which was set aside just a couple of weeks ago. And I think that not many people expected that it would be set aside, actually. So my last remarks is that I would like to mention two things that are useful to know when you design a multi-jurisdictional recovery scheme. The first thing is that in Europe you have the EU regulation on jurisdiction and enforcement of judgments, which allow you to easily enforce European judgments, a judgment rendered in one member state, to enforce it in all the other member states. And in my experience, it was quite useful. This feature was quite useful because you can, for example, start the main claim in Cyprus when there is some connection to Cyprus, pierce the corporate veil there, and then enforce that judgment in France. And the fact that the French law does not recognize the pierce of corporate veil cannot be an obstacle to the enforcement of the Cypriot judgment. Another useful thing is that in France you have quite a favorable legislation concerning prejudgment attachment of assets. I know that it is not always possible in the US to obtain a prejudgment attachment in aid of foreign court proceedings. Correct me if I'm wrong.
difficult.
So it is at least difficult. But in France, I think that even if you have a court proceeding in US, you can obtain the attachment of assets if they are located in France by showing that there is a prima facie claim, which is asserted in the US, and that there is a risk that the assets will be dissipated. And French courts are more, I would say, easily not piercing the corporate veil, but agreeing to take an attachment on a company which is not the direct debtor in aid of foreign proceedings, then they are piercing themselves the corporate veil. So if you have a US main action to pierce the corporate veil, attachment in France is one of the tools that has to be considered.
I'll clarify that point, by the way, just so that we have a good understanding. Yes, the US, unlike France, unlike Cayman, BVI, London, we have traditionally not offered to foreign litigants seizures for the sake of seizures. If you have an action going on in Cayman and there happens to be a US asset, it is not a given that you can get an attachment. In fact, New York just, a few years ago, but almost just, passed a special statute that allowed for prejudgment attachments in support of foreign arbitrations. The best you can do is make an argument when there is a simultaneous foreign proceeding going on that you should have an equitable right to a security-only action. Now, that is going on now. What you've not seen is any appellate precedent on the issue. So yes, difficult, and this goes to sort of the toolkit. Looking at the time and with fire drills and the like, I think we are going to shift now to questions, if there are any from the audience, before we wrap up.
Can I just do this same with you, Ivan? Is the same situation in respect of prejudgment? Sorry, I've got the rules. The prejudgment attachments in France, do the same rules apply in Germany? Do you know?
No, frankly, no, I don't know.
Same civil law jurisdiction?
I think it's because, for example, you have France and Switzerland, and I know that the approach is not the same. In Switzerland, it would be much more difficult to obtain an attachment in aid of a foreign action where you assert the pierce of corporate veil claim. So Germany, I didn't have experience trying to attach assets there.
And then
But it can be that it is more close to the Swiss law than to the French one.
I'll ask a German lawyer. I had a second question about the toolkit. You've mentioned insolvency proceedings, you've mentioned all the different jurisdictional, sort of overlapping jurisdictional tools you can use. Nobody's mentioned criminal actions. And I wonder why that is, particularly in England, where we do have private prosecutions, and they are increasingly, from what I've seen anyway, a go-to solution for international litigants where there is a dishonesty alleged in the fraud.
The issue with a prosecution is that even if you initiate a private prosecution, it will be taken over by the Crown Prosecution Service generally. I'm not a criminal lawyer, but that's my understanding of the situation. Once you put it in the hands of the police or someone else, it takes a very different path. Beyond your control, there might be a small amount of commercial leverage in saying to someone, if you don't do this, we'll report you to the police. But beyond that, it's unlikely, in my experience, to assist in effecting a recovery. It's not something that we would generally, even when I was in the UK, it wasn't something that we would generally consider. In the Cayman, and I can't speak for BVI, but in Cayman, good luck trying to get the police to investigate. That's all I'll say. Good luck. It's not something which we would generally consider. I mean, it would assist if you had a criminal judgment, someone was convicted of a crime. We do see quite commonly, actually, in fraud cases where principals have been convicted, they're in jail. You've got a slam dunk breach of fiduciary duty claim. There's no question about that. The problem is they're in jail, their assets have been confiscated. What's the point? You know, what you do is you put the claim in the hands of someone else who doesn't have the same commercial objectives that you do. There's a risk of losing control of the process. In my experience, the police aren't generally prepared to cooperate with lawyers who are trying to make a civil recovery. Confiscation proceedings or process of confiscation, the proceeds of confiscation proceedings don't end up in the hands of the victims. So in my experience, it's not an effective way of trying to enforce a judgment, effective civil recovery for the victims of the fraud.
I can say on the U.S. side, it's what your objective is. Most of the time when we're contacted, it's by parties who are looking for a speedy and efficacious resolution to their problem, which means money in their pockets. The problem when you bring in, let's just say, the U.S. attorney, is that all civil actions are stayed. They don't go forward at all. You can't pierce the corporate veil. They will target the company that engaged in the bad act. They will target the individuals. But it's a question of process. In addition to the fact that you've got a stay of civil actions, which means that from the perspective of prejudgment attachment, seizures, a lot of what we're talking about, your hands are tied, the issue of sort of loss of control is a big one. 98% of all cases settle. They settle on civil and commercial terms. And there's a reason for that. There is a proportionality between investment in a case, outcome, and realistic outcomes. And when you remove the ability of the victims to directly engage in a settlement themselves outside of the criminal process, it is a problem. It is a problem because what it means is that they have to win a trial, the authorities. You cannot begin a case and end it, let's say, 7 months later, which is often what people come to people like us for. I can tell you about 5 years ago, we engaged in a veil-piercing exercise in respect of a Chinese major, filed 18 actions in 18 different U.S. jurisdictions. I was driving courthouse to courthouse, seizing receivable to receivable. And the action was over in 9 months. 9 months. Within 9 months, the company that had engaged in judgment evasion had its hands tied, couldn't do business in an effective way, and a settlement was reached on commercial terms. Sometimes the frauds that we are talking about that give rise to the corporate veils are also crimes. There's no doubt about it. The question is, I think from our perspective, is people come to us with a very specific problem, sometimes a very specific budget, and they want their recovery soon, and they want a strategy which will result in a circumstance that they can control. And the problem is, as soon as you bring in the criminal authorities, I think you lose a bit of control, by definition. It becomes about proving a crime instead of being...
I said private prosecutions, not actions by a public authority. The CBS don't take over on private prosecutions, and you don't have private prosecutions in the U.S. And there you do have in civil law countries. I'm not talking about handing it to the police. I'm talking about prosecuting it yourself.
Like in Luxembourg.
It's in persona, so you don't have to place the corporate veil because you have the right to that.
Although even in Luxembourg, even with the private prosecution countries, the civil actions are state. I mean, we've got one going on right now where we're actually getting U.S. discovery and aid of a Luxembourg criminal action. And while the litigants are free prior to the commencement of that Luxembourg criminal action, this is exactly what you're talking about, which is the private prosecution. Even in Luxembourg, even in the private prosecution countries, your Luxembourgs, your Panamas, the civil component is state. And while the investigating magistrate is doing his job, frankly, there can't really be a settlement. Lawyers are sort of prohibited from relying on criminal actions to achieve a settlement in a lot of countries. So even there, I hear what you're saying, but the answer is even there in the private prosecution examples, and your perfect one is Luxembourg and Switzerland, the civil component is state. So it's an issue.
I have a question concerning the comment made with regard to aggressive restructurings. So is it to say that if you can allege that there has been an improper restructuring, you can then pretend that that's a tort and get the piercing of the corporate veil and get the shareholders to be responsible for that? Is that what you were saying about that specific
right
scenario?
Or try to, I wouldn't call it a tort, but yeah, the concept is that if parties engaged in a restructuring, and again, the two caveats being nominal economic value as a result of the restructuring and the effect of placing assets beyond the reach of creditors, yeah, if the purpose of the restructuring, let's say, is to transfer your unsecured notes to a third company, and that's the whole purpose, sure, I think there's an argument that that can be disregarded, that other entities within the group can be charged with liability under veil piercing and enterprise liabilities theories. Sure, that's the concept. It's already happening where certain aggressive restructurings are being challenged in Europe. I think the U.S. veil piercing mechanism is a way to effectively challenge those restructurings as well, because if you're just going to ignore it, what's the point in doing it? I think that's how it'll play out in practice.
So we're working on a restructuring case at the moment, which involved Cayman Topco trading listed subsidiary, which was restructured in a way that the subsidiary had something like 100,000 shares, which are held entirely by the Cayman company, issued 1 billion shares to dilute the Cayman holding from 100% to 0.01%, issued the shares to a Marshall Islands company, which then distributed the shares to the creditors of the trading company in satisfaction of its claims, and nothing went to the creditors of the Cayman Topco. Now, that is a good example of cross-border, because it's in Chapter 7 process in the US, it's in liquidation in Cayman. There is litigation now on foot in the US. We've been, as a result of the liquidation, we've been able to extract records from various service providers and advisors to the company who can't claim privilege because they're acting for the company, which is the subject of the liquidation. There is now in the US a claim on foot which has something like 24 different counts of claims against the directors for breach of fiduciary duty for allowing this process to happen. The trading PLC is a named defendant. So in none of those counts is there any suggestion of a piercing of the corporate veil. We have direct claims against the parties involved. So the third choice on my list was considered direct causes of action. And in all of those 24 counts, there's no need to pierce the corporate veil, because we do have obligations which are owed and breached, contracts which were in place which were breached. And so there is, I think, a way to seek redress which doesn't involve a piercing of the corporate veil. It depends on the facts of the case, and you could look to pierce a corporate veil in the right type of situation. In this kind of situation, you would probably look to say that the Marshall Islands company was a sham or facade. It had been there to evade obligations to creditors. But even then, the way the cases have been viewed in England, Cayman, BVI, you would say that the Marshall Islands company is an agent of the company which issued the shares to it. And so you don't need to pierce the corporate veil. You recover the shares under the principles of agency or resultant trust.
I think there, by the way, I agree. Under the Cayman law, you have the direct action, and at least there, by the way, in your case, you've got court backing for these plans. I think where you're getting into the territory that I was describing earlier is the out-of-court restructurings. That type of plan without the imprimatur of the judicial support, I think there is going to be there's going to be more fertile ground.
Yeah, that was what we would call a pre-pack. There was already an arrangement put together that the company entered provisional liquidation in the Cayman Islands as a means of preventing claims while the proposal was made to creditors. But it was done in such a way that the petition was anonymized. No one knew what the company was that had gone into liquidation. The offer to creditors was made at very short notice. without any real oversight by the liquidators in Cayman. So it was effectively like a kind of an attempt to restructure outside of a court process, but then with this sort of veneer of credibility by introducing the process at a very late stage, in circumstances where creditors had very little information about what was happening and how it was being done. So that's when you have these pre-pack cases, even with the court approval, there is a sense that a lot of this has been done behind the scenes without the approval of the court. So yeah, no, I agree that the involvement of the court process does add a veneer of credibility to the restructuring, which doesn't apply in the sort of out of process type arrangements. But even there, it was done in such a way that the court approval was really of no value.
Other questions, or we can wrap it up?
Back to the aggressive restructuring. One of the things that we've been seeing recently is where you have creditors, secured or unsecured, who are starting to sort of, breathe down the necks of the debtor, and the debtor will sort of put themselves into Chapter 11 and say they're going to restructure, and thereby, stalling everything. And, to your point, it's not really a genuine Chapter 11. They're not actually planning to take the assets out anywhere. They're just trying to buy time and put the creditors into a position where they have to negotiate. Is that the kind of thing you're talking about as well?
I take your point, let's put it that way. But I don't think what I'm describing would be viable in that circumstance. The U.S. courts, the U.S. bankruptcy courts, have taken the position that even a peppercorn of assets in the United States will provide sufficient jurisdiction for a Chapter 11. Now, to what you're talking about, it goes back to your other remedies. So there is a very clear doctrine on bad faith filings, especially whether voluntary or involuntary, particularly if it's effectively a two-party dispute. If it's one creditor, for example, leading the charge, either causing the Chapter 11 or forcing management to take that step. So you've got your two-party bad faith examples. You can have cases dismissed. There's also a fairly significant abstention doctrine. If your question about if this is being used as a delay tactic, there are remedies like seeking abstention and seeking bad faith. You can sometimes get attorney's fees. But no, I think that at least in the U.S., on the U.S. side, which again has at least comparatively more liberal veil piercing, although it's still tough. No, I think probably an 11 would not be grounds to pierce the corporate veil in the United States. Or at least we can try some more research, but there again, it's that imprimatur of legitimacy. It's not that they're taking actions hidden from the world. They're doing it right out in the open. And I think it's difficult for a court filing, absent a true fraud on the court, to be a ground to pierce the corporate veil. All right. With that, I'd like to thank our panelists, Mark, Ivan. See you at the cocktails.